All right, this is Justin Leto from Level Insurance, and I am here with Mike Fisher. Mike is a trial lawyer out of Seattle, Washington, and we're going to talk a little bit with Mike about some of his experiences with LevelEsq and Level Insurance, and also about a really interesting case that he worked on where he had Level Insurance in place and got a really bang-up amazing result. So Mike, first, thanks for taking the time to talk with us here. Tell us first a little bit about your firm, about your practice. I want to talk a little bit about your background. You were telling me this is like a cool room you guys set up, during the pandemic to look very professional. It's awesome. So just tell us a little bit about yourself.
Sure. So we're actually in Tacoma, Washington, about 35 miles south of Seattle. We're a small plaintiff's personal injury firm. We've got 7 partners, 1 associate. And with our staff, we're about 21 people. We handle all matter of plaintiff's personal injury, from your regular car accidents to some pretty complicated medical malpractice, nursing home, negligence cases, things like that, insurance bad faith. So kind of the whole gamut of typical cases you'd see for personal injury practice on the plaintiff side.
That's great, man. So you guys have got 7 lawyers. I think that's kind of a good size plaintiff's firm, actually. Most firms have 2, 3 lawyers, some bigger, but that's a pretty good sized firm. Are these guys all practicing in different areas, or is it mostly focusing on the product liability, personal injury stuff?
We all pretty much practice in the same area. We've kind of been going through transition the last couple of years because a couple of my partners are in their early 70s and they're on the verge of kind of not fully retiring, but maybe slowing down, going to half-time. And so we wanted to bring in some new blood, so to speak, so that our firm kind of maintained the same size once the older guys fully retired. So last year we added a couple of partners and we added an associate, so that we should balance out to about 6 or 7 lawyers total once the 2 older guys kind of retire or go of counsel. Very
cool. All right. So I know that you're a client of Level Insurance, which is now called LevelEsq. And we recently saw each other at the American Association for Justice conference, and we got to talking. And you told me about a really cool case that you were working on, a really difficult case, actually, where you had Level Insurance in place. And so when you told me about it, I thought this was a great opportunity, not just for us to talk about the benefits of the insurance itself, but really the kind of cases that folks are using the insurance for to really get that upper hand to be able to go the distance. So why don't you tell everyone who's listening a little bit about the case, and if you can elaborate a bit on why you chose to use the insurance and what kind of benefit that provided your firm.
Sure. So I think typically you would think of cost insurance or the product that Level provides in a case like a medical malpractice or a nursing home negligence case, where you're going to have a lot of doctors involved as witnesses on both sides. And when you get a lot of doctors involved, they're expensive. And so, going into those cases, you're going to spend a lot in terms of cost to get it to trial. And we're a trial firm here. We take cases to trial. So every case that we take, we're anticipating we're going to have to run it all the way through trial. But there are other cases where it might not involve medical malpractice, but you still know, because of various reasons, you're going to have to spend a lot in terms of cost to get the case prepared. And the Andrade case was one of those. It was against the Tacoma Police Department. One of their officers actually ran over our client with the car, and horrible injuries. He survived, thankfully, but horrible injuries. And we knew that it was going to involve doing a complete reconstruction of the collision because it happened at night and there were issues related to visibility, speed, that sort of thing. So we knew we were going to have some experts involved that weren't necessarily as expensive as a doctor, but we're going to have to do a lot of work. So in terms of the amount of time they spent, we knew the costs were going to be pretty high. And anytime you're suing a governmental entity, it's sort of like a large insurance company. They have virtually unlimited resources. And so, you're going to have to do all the things that you need to do on your end to compete with that. And that requires the incurring a lot in the way of costs.
And so you guys used Level Insurance. You bought the insurance because you knew you're going to have to put all this extra cash into the case, and you wanted that back end protection. I assume that when you took this case, you thought that there was a reasonable possibility that they would not pay and that you'd have to go to trial because the facts were kind of tough. So you figured this was the best way to protect yourself.
Absolutely. Not only a reasonable chance that they would not pay, but a very reasonable chance that we would not win the case.
Right.
At the time that this incident happened, our client, Mr. Andrade, who was a Afghanistan war veteran, he'd come back from combat. He'd been dealing with some anxiety and PTSD and sort of things that a lot of people in our community, because we have a large military base here, Joint Base Lewis McChord, a lot of returning soldiers were dealing with, and frankly, the military and the federal government wasn't providing adequate assistance to those guys. So he was self-medicating with alcohol. He was drinking too much because he was dealing with all these issues, and the military had basically told him, now you're fine, you're ready to go back to duty. So on this particular night, he was out with some friends drinking at a bar in a local area here where there's a whole bunch of bars kind of congregated in the same area. Got to be about 12:30, 1 o'clock in the morning. He had had too much to drink, admittedly. Mr. Andrade was not just drunk, he was really drunk. He was almost 3 times the legal limit.
Wow.
And he gave his keys to his friend who was there with him and said, I'm going to go sleep it off in my car. So he walks out of the bar, down about a block, and down a side street where he had parked, and he intended to get in his car and basically sleep it off for the night. Didn't have his keys, so there was no risk of him driving. And he wasn't feeling well, probably because he had so much to drink. And so he kind of got down on his hands and knees like he was going to get sick, and then just kind of laid down and passed out. He believes that he, at the time, because his memory is a little fuzzy now, he thought he was on the sidewalk, but unfortunately he was actually in the lane of travel on this roadway. And then the police car came along and ran him over. So we have a
time out for a second. So I want to interrupt because this is kind of the way that you presented it to me when you first told me about the case. And as a trial lawyer myself, my initial reaction was like, how on earth are you possibly gonna win a case like that? Because you have a guy, regardless of the reason why he was drinking, juries don't like that kind of stuff. He laid down and fell asleep in the road, and a police officer came along and ran him over. When you hear those facts alone, it sounds very difficult. But now, after speaking with you, I know that there's other information about the police officer that you were able to present that really sort of turned the tide here. But I know you were first going to tell a little bit about the important statute that exists in Washington that you had to battle over in order to win this case.
Yes, because we have what's called an intoxication defense. So for any non-lawyers watching this, normally, if you're a plaintiff who's injured, but you were partially at fault for your injury, let's say you're 25% at fault, and just to make the math easy, say that your damages are $100. Because you're 25% at fault, you can only collect $75. Your damages are reduced by your percentage of fault. And that would work if you were 95% at fault. You would collect $5, using the same kind of silly example. The intoxication defense says that if you're found more than 50% at fault and you were intoxicated at the time of your injury, your claim is barred. So you get nothing. So it's sort of an all or nothing. So not only were we looking at the fact that our guy was really drunk, jurors don't like that, he was in the lane of travel. In any case, that in and of itself would be a problem. But with this intoxication defense, we really faced a risk of the jury finding our guy more than 50% at fault, and his claim would be completely barred. So that was a huge challenge.
So tell us, so now obviously you've given us what I think would be the defense's side of things. Like the guy was drunk, he fell asleep in the middle of the street, poor police officer doing his job, drives up and runs him over. How could the city or the police department possibly be at fault? But why don't you tell us a little bit about what was going on the other side that made this case more attractive for you and better for your client?
Sure. So this particular police officer, he'd been a police officer for 6 or 7 years down in Florida in the Fort Myers area, which I don't know how close that is to where you're at, but I know he came from Fort Myers, Florida.
Yeah, it's like 2 hours on the west coast of Florida.
Okay. And as you can probably relate to, he didn't really care for wearing the body armor and all the gear with that heat and humidity. So he wanted to come to a place that a little bit more temperate climate. So he ended up coming up here to Washington and joining the Tacoma Police Department. He was still technically, even though he was a lateral transfer, he was still technically on probation. So he was a probationary officer with Tacoma. And he had just finished his kind of in-field training about 2 or 3 weeks before this. So he'd only been in a car by himself driving around patrolling for about 2 or 3 weeks. Still not really familiar with the area. They're not supposed to do this, but he had a Garmin, kind of a GPS, a homemade, or a one that he owned himself that he had in the car because he didn't know the area enough yet to get around all the places that, you know, police officers need to get to in a hurry. So he was leaving a call and he was coming down this side street where Mr. Andrade was laying in the street. It's 20 miles an hour. There's no center divider, but there's some, I'm trying to recall the facts here. It's been a little while. There's a number of street lights and security lights on buildings. So the area is fairly well lit. And he was only going down the road about 3 or 4 miles an hour. And what he was doing is in his police car, he has a laptop. And with those laptops, police officers can essentially text message back and forth, just like we do with phones. They can do it on their dispatch system in the car. And so he was messaging back and forth with another officer about where to get lunch, even though it was 1 in the morning, it's his lunch break, because he wasn't familiar with the area. But instead of pulling over and doing that, he was doing that while he was driving. So he was coming down the road slowly, but he was turned to his right, focused on his laptop, and his car was kind of starting and stopping because he would try and stop the car, but he'd get so focused on his messaging that he'd kind of let up pressure on the brake pedal and the car would start to creep forward. And then he'd finally realize it was creeping forward. He'd stop again and go back to messaging. So he did this several times as he came down the street, all the while approaching Mr. Andrade laying there in the street. Unfortunately, by the time he finished his messaging with the other officer, he was stopped only about 9 feet away from Mr. Andrade. And at that point, he finally looks up out of the windshield and he's going to drive forward. He was close enough that he couldn't see Mr. Andrade over the hood of his car. And so he accelerated just like anybody would, and unfortunately drove over him with both sets of wheels and actually drug him down the road about 9 or 10 feet and then went another 18 or 20 feet before you finally see his brake lights come on. So it was actually about 7 or 8 seconds from the time that his front tire hit Mr. Andrade till he finally even applies the brakes.
Wow.
So when we were analyzing this, we're thinking, okay, we have liability issues on our side because Mr. Andrade was intoxicated and laying in the street. But this was clearly a case from our perspective of distracted driving by the officer, and not just for the period leading up to actually striking Mr. Andrade, but you could tell by the way that it took him so long to even brake after running over him with both sets of tires, that his mind was not on driving. His mind was on getting something to eat or finding a place to have lunch. And so given all that, and Mr. Andrade was very seriously injured, we felt that it was a righteous case and one that we should pursue on his behalf against the police department.
Sorry about that. Turn that ringer off there. But that's an interesting set of facts there. And I think you had told me also, though, that police officers are permitted to text and drive, though. They have an exclusion to the law that we have to follow where they can still text and drive. So is there a way that you presented this evidence or anything interesting about the evidence that you were able to show the jury that weighed the case more in your favor?
Yeah, so that was interesting. One of the things that we didn't discuss yet when we were talking about costs is there are a whole bunch of things you can do to prepare for trial. There are a bunch of things you have to do to work a case up. And a lot of that is done with an eye towards settlement, depending on the lawyer or the firm. But there are a number of other things that you can do if you're going to get ready for trial, but you don't necessarily have to do. And one of those is focus groups. And focus groups is where you basically bring in mock jurors and you present fact patterns to them or whatever you want to do, and you get their feedback. Because as objective as we try and be, we're lawyers. So we look at the world a little different. we're representing the plaintiff. So even if we try and be objective, it's really hard to really be objective.
Right.
But you bring in a bunch of strangers in a focus group and they don't have a dog in the fight, and you get real honest feedback about what's important to them. So having the cost insurance in place, in this case through Level, we knew that we had some level of protection for those expenditures. And so we did about 27 or 28 focus groups, I think, over the course of about 2 years.
Wow.
In order to get this case ready for trial. And so that was a big help.
What did that, so 27 to 28 focus groups. First of all, if you did not have the insurance, do you think there's a chance that you would have either done none or less of those focus groups because of the extraordinary expense?
Definitely less. I certainly think we would have had to have done some, just given the facts that we've discussed. We had to get some sense of what people would think about all this. Because we had to know, are they just absolutely going to hate and be pissed off at our client for being so drunk that they're not even going to consider anything else? So we would have done some, but not nearly to the level that we did. Being able to do that many really allowed us to refine some things, refine some arguments. We practiced voir dire or jury selection and got feedback on that. We practiced opening statements. We took the feedback we got in jury selection and used that to kind of reframe how we asked our questions, some of the words that we used, in order to really flush out jurors that wouldn't be appropriate for the case because they couldn't be impartial no matter how hard they tried. So that was a real benefit in this case, to be able to have the ability to do that.
Well, it's pretty cool because some of the things that we've always told lawyers when we're trying to explain the benefits of Level Insurance is there are so many things that we can do as trial lawyers that will enhance the value or the presentation of the case. Some of which you must do, ethically or to avoid being accused of committing legal malpractice, but many of which are voluntary and they're choices that lawyers have, whether they want to go and spend that extra money and do those things, call those extra witnesses, spend that money on the focus groups. And those things can become daunting expense-wise, especially in a case like this one, where your client clearly has arguments to his benefit, but you as a lawyer who is putting out all your own money on the case, you have a lot of risk because your client did some things in this case that clearly a jury could find to be greater than a 50% fault on his behalf. So you had that extra firepower in your arsenal that you could now go out and do these extra things to enhance the arguments that you were going to make in the case.
Right. I'll tell you a quick story that I think really highlights that, because one of the things that's really beneficial about the way you guys have your insurance structured is you don't micromanage what's a case cost. You basically say, you buy this protection, whatever amount, you pay the premium, and you do what you need to do to prosecute your case. And if it goes south, the insurance will be there, and we're not going to come in and micromanage and say, well, that's not a legitimate case cost, so that should have been less. So that's very helpful. And I think this will illustrate it. So one of the issues that we had in this case is, because the defense from the police department was, yeah, the officer wasn't looking at the roadway, but it was dark out. Mr. Andrade was wearing dark clothing. So even if he had looked at the roadway, he wouldn't have been able to see him. So sort of I made a mistake, but no harm, no foul, because it didn't make a difference. And we had to counteract that. We knew we had to counteract that. And so we did a complete reconstruction of this collision out on location at 1 a.m. with a surrogate laying in the road wearing the exact same clothes that we purchased, a Hispanic guy, because Mr. Andrade was Hispanic, so he had darker skin. That all goes to visibility. In order to do those recreations, though, you need a vehicle. And you almost always have to go out and say, okay, the defendant was driving such and such vehicle, 1982 Honda Accord. We need to go find a 1982 Honda Accord to use. Well, in this case, after this happened, the police department knew there was going to be a claim. So they had their experts come out and completely evaluate and test and photograph and do everything they needed to do with this particular patrol car. And then they suddenly determined that it was beyond its useful life, and they auctioned it off. before we ever had a chance to have our experts look at it, which creates a problem. Now, the typical response of lawyers would be to bring what's called a motion for spoliation and basically go to the court and complain that they did this and seek some relief, whether it's a monetary penalty or, whatever it is. You can do that, but that doesn't really help you win trial, especially when you got difficult issues like we do. So what we did was I figured out who they auctioned the car through. And through the auction, I figured out who they sold the car to. I contacted that individual and purchased the car from him. So we actually owned the very police car that was being driven by this officer when he ran over our client.
Wait, hold on. Let me just, because I want to highlight this from you. This is really, because this is really cool information. So the police department actually got rid of the evidence before you had a chance to evaluate it?
They did.
And so you had no opportunity. They did all their forensic work, obviously skewed to whatever they thought was best for them. They went through the whole process, likely reconstructed the accident, took measurements, and then said, you know what, we're done with this car, and they auctioned it off. And so you, as a really diligent lawyer, had to go out, find the auction, and then go and offer to buy the vehicle from the people that bought it at auction. Correct. That's a lot of work. And I'm sure that I imagine that the folks who bought this older police car at auction were thrilled that all of a sudden they had this asset that they could sort of set the price on for you guys to buy it, right?
Yes, they made a bit of a premium on the car in order for us to get possession of it. But,
And so you were able to actually go, though, into trial and say, we're not using some replicate of the vehicle. And were you able to tell the jury that the police department got rid of this car and that you had to go out and find it and recreate the whole thing yourself?
We did not. And we didn't ask to do that because we didn't. Everybody has a different philosophy on these things. I know, like, for example, the common thing you see is a defendant will deny liability right up till the day of trial, and then come in at trial and go, we're going to admit liability for purposes of the trial. And some plaintiffs' lawyers jump up and down and they want to be able to tell the jury that. And I think they do that because they think that somehow the jurors will be as upset as they are that the defense was jerking them around.
Right, right.
I don't see it that way. And I've been to some seminars and talked with some people that do a lot more trial work than I do that kind of look at it the same way. I think jurors expect lawyers to screw with each other. And so they don't get bent out of shape if you come in and say, well, look what they did. They strung me along all this time. They just expect that that's what happens. So we didn't want to make a big deal of that because I didn't think it was relevant to what the jury was trying to decide in the case. And we were, from our perspective, talking about very serious injuries to our client. And this was a very serious matter. And we didn't want to get into this ticky-tack, kind of minor inconveniences or however you want to phrase it. So I didn't even go there. I didn't even make an effort to go there. I didn't think it was valuable in this particular case. In some cases it could be.
No, that makes sense. I guess I was thinking more in terms of like spoliation of evidence. If there was any argument to be made that they had their bite at the apple to investigate all this stuff, and then they went ahead and got rid of the evidence. But I hear what you're saying. But I remember when we spoke, Mike, you told me that because they never asked, you never actually had to tell the defense that you were bringing the real car into trial, right?
Correct. And, to be fair, if we hadn't been able to locate the car, we probably would have looked at some sort of spoliation motion. But because we were able to get the car and the way that we had to get it, we didn't have to tell the defense that we had it, and they never asked. So it was probably a week or two before trial when we were actually getting trial exhibits ready. And that during that process, the lawyers have to work together, that they finally realized that we had the actual car. They had videos of the recreations that we had done, but they thought it was an exemplar car. They didn't know it was the exact same car.
Wow.
And so whenever you're doing a recreation, you're trying your best to make it exactly the same as the original incident. And that's almost impossible to do. But you try and cover as many factors or as many elements as you can to make it as close as you can, to the real thing. And almost always you have a different car. So having the actual car was very helpful in this particular case. Even though we had established through deposition and through written discovery, we got maintenance documents from the police department. We took the deposition of the driver, the officer that was driving the car. No issues with the headlights, no issues with the electrical system. They were working fine, blah, blah, blah. Those things were still raised at trial and kind of hinted at by the defense, as they often are. And, you know, I was able to impeach the officer on the stand with his deposition testimony, where he said, no, the lights were working fine, which is what we would typically do. But we were also able to say, and by the way, we have the actual car. Wow. And we've had a professional certified mechanic go through it and test the electrical system. We've had our accident reconstruction professional, who was also a former police officer, who has driven it multiple times and tested it. So not only do we have your deposition testimony saying there's no problems with the car, but we've established through other means that there actually is no issue with the electrical system in the car. And that's important, because those little things that the defense kind of throws out there, they can hang in the jurors' minds if you don't address them. And since we had been able to do all of these things, in part because we felt more confident having cost insurance, we were able to head a lot of those things off. And, you know, this was a case where, you know, in some cases on the plaintiff side, you can explain away one thing, you can maybe explain away two things. Given the liability issues, we did not want to be in the situation of trying to explain away things or asking the jurors to overlook things. You know, we wanted to come in and be as rock solid as we can and say, we've got all these things covered. The issue you have to decide is fault here.
That's pretty incredible. So, and I'm looking at your policy. It looks like you guys had about $200,000 in coverage. So you guys weren't messing around. I mean, this was expected to be an expensive case, and you knew it right from the beginning, and you got a significant amount of coverage for it.
Right. And we actually spent more than that. We spent about $230,000 or $240,000, I believe.
Wow. And what, tell us what the result of the case, tell us the result of the trial.
Well, before that, let me just jump back to what we were starting to talk about. So, and I think this highlights the benefit of having the insurance in place. So we did a full recreation. Our guy came out, we were out there all night. I mean, it got to the point where we had to stop because the sun was coming up, and that was interfering with the visibility. Wow. So we've got our reconstruction guy out there. We've got our surrogate laying in the road. We've got our human factors person there, and we're doing drive-throughs. We forgot to mention at the beginning of this, there was a security video from a home security system at a neighboring house that captured this accident on video.
The actual gentleman getting run over by the car was captured on a video?
Correct.
How did you find that? How'd you figure that out?
The police department actually figured it out because they saw the cameras on the house and they contacted the homeowner. And so they gathered all that as evidence. And so we were able to get a copy of it. Of course, the news media got a copy of it. It's actually on YouTube. People can look it up and watch it. So we knew exactly, at least in the frame of the video, the last 3 or 4 stops, we knew exactly where the car stopped and what the distances were and how long it took it to travel and whatnot. So we did this whole recreation to be able to show with video and photos looking out the window that the officer actually could have seen Mr. Andrade laying in the road very well had he been looking, because the defense was, even if he looked, he couldn't have seen it. So we do this whole recreation. I think we spent $35,000, $40,000 to get that done. Wow. It was very involved, very detailed. We were very proud of it. So now we go back and we start running focus groups with it, because we want to get focus group jurors' impressions of it. What do they think? Do they agree that this highlights what we're trying to show? Do they have any questions about it being authentic or an accurate recreation? And I think I'm a big fan of focus groups. I think you get a nugget of knowledge that's useful probably in every one. And it usually happens like it did here. Some unassuming person in the back raises their hand and says, did you have a laptop in the car on when you were doing the recreation? We did not. Multiple lawyers, multiple experts, accident reconstructionists, human factors. Nobody thought we should put a laptop in the car because the officer had a laptop and the light from the screen might possibly could impact visibility.
Interesting.
Now, both the human factors and reconstruction experts said it won't make any difference, but it was important to the jurors. And so what we actually did, and again, I think this we only did because we had insurance through your company, is we brought the reconstructionist out because he's from out of state, and we redid the entire thing again.
Get out of here. You did it a whole second time?
We did it a whole second time, and I had gone out and I'd purchased the same laptop that was being used by the Tacoma Police Department at that time. We got a screenshot of a police dispatch program that we saved as the screen, background screen, and so that it would be a similar level of light to what would have been on it. And we completely redid the entire reconstruction again at a cost of another $35,000 or $40,000.
That's amazing.
Because it was important to the jurors. And as it turns out, it would have been important to the jurors who actually heard our case, because if you're not an expert in this, most of us don't drive around with laptops in our car.
Right.
I think the general thinking is if you've got a screen blaring at you, you're not going to be able to see out of the windshield as well.
But
so that ended up being,
and I'm sorry to interrupt, that piece of information, the use of the light, is the reason why you thought that it was important, or that the potential juror or the focus group juror thought that it was important, was that if it was reflecting back on the officer's face, that would actually support the defense theory that there's no way he could have actually seen Mr. Andrade?
Correct.
And so you had to disprove that because that was something that was in the mind of one of the focus group jurors.
Correct.
Wow.
Well, one of the focus group jurors that actually raised their hand and mentioned it. We did a couple focus groups, and once we started bringing it up, now that we'd been told that one of the jurors had a concern about it, multiple people said, yeah, no, that's a good point. And so, you know, that was
Did you interview the jurors? Did you interview the actual jurors in your trial after the case and find out whether that piece of information that you uncovered was actually important to them?
Yes, the accuracy of the recreation that we did was very important to them, because the story that they're given is guy wearing dark clothing on a dark street laying down. You wouldn't be able to see him. Everybody has this image in their head of a dark street and you can't see the guy, and, you know, there, but for the grace of God, go I. If I'm driving down the road and I can't see somebody, I don't want to be at fault for it. In reality, you could actually see him very well. It's not so much about the lighting, it's more about the contrast. And so even though it's a dark street with the street lights blaring down on it, the street actually looks to be a light gray. And so it made his dark colored clothing contrast the light gray. So even though he was wearing dark clothing, he actually stood out more than he would have if he'd been wearing lighter colored clothing, which would tend to blend into the kind of light gray appearance from the reflection of the lights off the road. So that was very important to them, because the actual police officer defendant, he's, you know, you have different impressions of law enforcement. You know, there's some bully cops out there, and we hear about cops doing things they're not supposed to do. He's actually personally a very nice guy. He's not somebody that, and this is something that you have to consider as a lawyer and something that jurors consider, because they're going to evaluate somebody's credibility based on how they present. He's not somebody that the jurors were just going to dislike.
Right.
And it wasn't an act. I mean, we worked on this case for 7 years before we finally got to trial. In reality, he was a nice guy. You know, he made a mistake. He wasn't actually the one pushing this. It was the city attorney's office that was fighting this. He was kind of along for the ride, unfortunately for him. But
wow.
But yeah, all that was very important to the jurors in terms of evaluating whether or not he could see had he been looking.
So you presented this case to the jury. How many days did the trial last? And tell us what the result was. Because I know the result because we've talked about it, and I find it to be fascinating considering the statute.
So the trial lasted about 2.5 weeks. We tried it last summer, August, kind of in between waves of COVID. So we weren't actually at the courthouse. We were at a community center in kind of a really large room, so that the jurors could all be spread out. The public wasn't allowed into what we were using as a courtroom because of COVID, but the trial was being live streamed on YouTube. So it's still an open public courtroom. Anybody could watch it. So that added some challenges. It was also during a time period where we were having 105, 108-degree weather here, which for us is very unusual. This community center was about 50 years old, and so was the HVAC system. So it wasn't able to.
Oh man.
So there were several days where the judge had us start court an hour early, and we'd end at 2:30 or 3, which normally judges don't do because they want to be respectful of the jurors' time. But that added a couple days, and the jurors were actually on board because it was just too hot.
And you had to wear masks too, right? And you had to wear masks during the trial?
You had to wear masks unless you were speaking. The jurors had to wear masks the whole day sitting there.
Wow.
So again, being sensitive to them because they're not there because they want to be. We were trying to be as efficient as possible. But so about 2.5 weeks of trial, they deliberated for 2.5 days. And their ultimate result was a verdict of $3.5 million in damages. They split liability 50-50. So that means that Mr. Andrade was able to collect on his claim because he wasn't found more than 50% at fault. So he basically got to collect 50% of $3.5 million.
That's an excellent result. That really is for that kind of case. And did the jury know about the statute? Were they aware that if they would have gone 51-49, that he would have gotten nothing?
Kind of. So there's a pet peeve of mine, but I'll try not to get on my soapbox. So the intoxication defense is actually codified in a statute in Washington. It is also written out in a standard form jury instruction. The language of the jury instruction does not 100% mirror the statute. And it doesn't specifically tell the jurors what the consequences are if they find the plaintiff more than 50% at fault. Now, if you or I as lawyers read it, we'll go, oh yeah, that's what that means. But it's not clear to people that aren't trained that way or don't read things that way necessarily. So I wanted to tell the jury in closing, because normally you're allowed to fairly discuss jury instructions that the court has given to the jurors. I wanted to tell the jury what it meant if they found him more than 50% at fault. And the defense opposed that, and the judge ultimately went with the defense and said, no, you can't do that. Limited me to basically reading the instruction to them. So I was able to read the instruction to them and try and use vocal and visual kind of emphasis. But we learned after, because all the jurors stayed and chatted with us for about 3 or 4 hours. They were heavily and emotionally invested in this case. They struggled with what that meant. They spent almost an entire afternoon, 3 or 4 hours, which in jury deliberation time, as you know, is forever.
Yeah, that's a long time.
Just trying to figure out what this meant. They sent out a question asking if that's what it meant. And of course, I'm there in front of the judge going, this is exactly the problem that I was concerned about. And so again, I wanted the judge to instruct them, which is entirely consistent with the law, that if they found Mr. Andrade more than 50% at fault, he collects 0. The judge ultimately refused to do it because he hadn't allowed us to do it in closing. So neither I nor the defense lawyer had been able to discuss it. So she felt that the most appropriate thing to do was to just tell the jury, read the instructions again. So that caused us a lot of concern during deliberations. But at the end of the day, they kind of deduced on their own that if they found him more than 50% at fault, he'd get nothing.
Yeah, it sounds like the verdict speaks to that, but I got to say, like, there is another way to look at this. As a trial lawyer, I feel like we always believe that we understand and can feel what the jury thinks or how they're interpreting things. But there always is the possibility that if they knew that, they would have felt righteous in finding him 49% at fault by saying the police officer had done something wrong, but that because of his actions, that he should not collect money from the city. So perhaps there could have been a double-edged sword there if you would have been able to tell them that could have maybe worked against you. We'll never know, I guess, but there's always that possibility.
Right. What it did do was it removed an appellate issue for the defense after the verdict was rendered because the defense got what they wanted.
Yeah, that's true too.
So if the judge had instructed him as I was requesting, that's possibly something that the defense could have used to appeal. It's also for any lawyers watching this, it's always, post-trial, you want to get lessons learned and how you would do things different again. We did not focus group the intoxication defense. And all the focus groups we did, because we weren't disputing that he was drunk. We were admitting, which I think we had to, that not only was he drunk, he was really drunk.
Yeah.
He was very drunk. I mean, we at various times we described him as hammered. We didn't sugarcoat it at all.
That was smart.
Try and lawyer around it, well, he had consumed it, blah, blah, blah. We didn't do any of that. So he was flat out hammered. He was drunk. He shouldn't have been that drunk. We told him that up front. So we never really focused on the intoxication defense issue as much because we thought, well, we're not fighting that. Moving forward, next time I have a case involving this, you can bet that I'm going to focus group with the jurors. Here's the jury instruction for the intoxication defense. What do you think this means? And see if we can figure out, assuming that the next judge will not let me explain it as I wanted to, so I'm in the same situation, try and figure out if there's a way to convey that information to the jury, that that's what it means without, violating a motion in limine or a court order or having to just blatantly say, this is what it means. So that's definitely something that moving forward, I would explore again with the focus group. And admittedly, I missed that. We didn't test that at all.
I got to tell you something, Mike. I practiced myself for about 15 years before I moved into this business. And I probably tried 15 cases to jury and to verdict. And all cases are interesting. But this particular case is striking, not just because of the facts, but because of the diligence that you and your firm utilized to make sure that you covered all your bases. I mean, I'm just really impressed by the amount that you were willing to spend, the fact that you had one little piece missing and you went back out and redid the entire focus group to make sure that you got it right. Your client and all of your clients should be very thankful that your firm is as diligent as they are. And I'm really happy to know that Level Insurance played a role in allowing your firm to be able to go that extra step, because that's really why we designed this program. Is as cliche as it may sound, it is true that when Larry and I designed Level Insurance, we were both practicing at the time, and we were trying to solve a problem where lawyers are required really at this point to advance all their own money for your clients, because that's what's expected. But that at the end of the day, you put all your time and all your heart and all your energy into it. And if you're not successful, despite how difficult the case is, despite the risk that you take, there was never anything that would allow you at least recover what the investment of out-of-pocket money is. So the fact that you all used it to this extent is exactly what we would want, what we would expect. And we're really proud to be a part of it.
Absolutely. And, we've admittedly been fortunate because we've got multiple lawyers here. And so we have some resources because we do medical malpractice cases. So we know that you're going to have to, front a certain amount of costs. And if you try cases, you're going to lose cases, especially medical malpractice cases.
Yeah.
And so we're always kind of trying to plan ahead for, hey, if you try a case and lose it, you're probably going to have 6 figures in costs that the client can't pay, and you're kind of down the drain. But we're set up to take a few of those hits and still be standing. I know there's a lot of lawyers that may be a solo or only 1 or 2 or 3 lawyers in a firm that does, I don't want to say less complicated, but maybe less expensive in terms of cost type cases. And then they get a case like this in that they could handle in terms of ability, but they can't handle it in terms of the cost risk. And so they find themselves either having to associate with another firm to spread that economic risk out, which maybe they don't want to do. Having a product like and a service like this available, for those situations is perfect, because now they can take the case and run with it and do what they need to do, and know at the end of the day, if things go really bad, which they can, they've got some protection.
Well, listen, Mike, I can't tell you how much we appreciate you taking the time to go over this. And again, congratulations on an excellent result. The firm is Rush, Hanula, Harkins, and Kyler. Did I say that correctly?
You did. Nice job.
All right. So Rush, Hanula, Harkins, and Kyler, and Mike Fisher in Tacoma, Washington. I got to tell you, lawyers who use our product or are watching this and have cases in Washington State that need to refer cases there, these are guys obviously that have proven throughout this conversation are well worth a look for that. So thank you again for your time, and we hope that you continue to use Level Insurance to really increase all the value in your cases.
Thank you, Justin. Appreciate it.
All right, Mike. Thanks.